Yes, I salute you all. Thanks for listening and thanks for watching. So basically today we are under criminal law 1, and the topic that we are going to look at rape as a topic, as an offense under criminal law 1. And before going further, the onus is on the prosecution to prove beyond reasonable doubt. I'll continue repeating that because even if you are answering an offense, give a stand that you are the prosecution, the burden falls on you to prove beyond reasonable doubt, which means you must prove each ingredient and each element. You get? So basically, note that in what? In mind. So under rape is provided under section 100, 110 of the PCA, section 110 of the PCA, and it provides for the offense of rape, basically. And the person that is found, actually, we are going to look at the elements. I don't want, because the elements define what rape is. You get? And there is a saying that a man cannot rape a wife. And remember, actually, rape normally it is an offense only on woman. A woman cannot rape a man, but a man can rape what? A woman. So it is an offense only on women. So basically, nevertheless, we are going to see that there's a saying that says that a man cannot rape a woman. A husband cannot rape a wife. But however, where there is a separation, a judicial separation, judicial separation is not divorce, but it is temporarily, it is suspension of conjugal rights. Where there is a temporary judicial separation, a husband can rape a wife. Note that in what? In mind. Because there is a case of Rex versus Clark and Regina versus Miller. Those cases provide that where there is an order issued by court for separation, once a husband forces the wife into sex, it is rape. You get? But nevertheless, you are going to go to the ingredients of what? Of rape. These ingredients of rape, they are in the case of Uganda versus Balikamanya. Yeah, Uganda versus Balikamanya. First of all, that case provided that there shall be carnal knowledge. Carnal knowledge is penetration. Secondly, there shall be lack of consent. And thirdly, participation. Okay, those are the three crucial elements of rape. And what you have to know, as we are going to discuss one by one, we shall first come with carnal knowledge. Carnal knowledge, it means penetration. However slight it is, so long as you can never prove rape where there is no penetration. Penetration is the evidence that proves rape. Where there is no penetration, there is no rape. However, intention, even if there is intention, what or not, you look for other offenses, maybe indecent assault, but there is no rape. Rape, there must be penetration, however slight it is, so long as the penis enters the vagina. However slight it is, so long as it enters, it amounts to penetration, which is carnal knowledge. And it is the key element that makes rape, which is penetration. You get? There is a case of Basita Hussein versus Uganda. It is the case that discussed about what they mean by penetration, whereby they explain that the act of sexual intercourse or penetration may be proved by direct or circumstantial or corroboration. However much actually the precedent changed. In sexual offenses, there is no more corroboration. So basically here, realize that a medical report can be as a circumstantial evidence. Medical report, that's why when you hear that rape cases, they go to the medical, what and what, to prove that maybe there was what? There was penetration among the circumstances. So it can be either proved by circumstantial evidence, that is carnal knowledge, as we shall see, whereby they can even get pubic hair around the vaginal part, they can get sperms around. So that is circumstantial evidence that proves that indeed there was what? Penetration. So basically, that was one of the elements. Then another element for rape, it is lack of consent. Lack of consent is an element, and we are going to look at the forms of lack of consent. What you have to bear in mind, or what you have to put in mind, lack of consent is that you do something unwillingful. You get unwillingful when you are not willing. First of all, the general rule: people below the age of 18, they cannot consent. Anyone below the age of 18 cannot what? Consent. When you read the case of Nakoli versus Republic, the girl was 13 years of age, so she couldn't consent because he was the age of below 18. However much, even if she has accepted, so long as it's a minor, minors cannot consent. So basically, note that in mind. Another element that we see, it is the element of force, where they use force that deprives lack of consent. And this element of force was portrayed in the case, actually it was portrayed in the case of Uganda versus Ospira force, where the accused person used the forceful measures to grab the girl and rape. You get? So that is force. Then we have impersonation. Impersonation, you disguise yourself in another one. Here we are looking at the forms of lack of consent. We have seen force, then we are going to impersonation. Impersonation basically it deals basically whereby, for example, the case of Rex versus Joseph Jackson. This person impersonated himself as the husband. You get? He went in bed, he found the wife sleeping. So the wife was married, and he thought maybe it was the man that had come back. So he had sex with him. Only to realize that the person was not his husband. So that amounts to impersonation. You get someone consent out of impersonation. However much, even if she has accepted, but under a misrepresentation, it amounts to lack of what? Consent. You get? Then we also have the case of R versus Mayers. Mayers is Myer. Basically, here they said that a person of a low age or in sound mind, a person that is asleep, he cannot consent. Basically, that's what was in the case of R versus Mayer. Then we have a concept that is obtained by fraud. Where there is fraud, there is lack of consent. What do I mean by fraud? Fraud is like a misrepresentation. You mispresent someone for something else. For example, there is a case of R versus flattery. R versus flattery. This one used he had sex with a woman in disguise that he was performing a surgical operation. He was a doctor. So he lied the woman that was performing a surgical operation. Hence, for him, he was penetrating busy. So that is obtaining consent out of what? Out of fraud, basically. Then also still under fraud, there's also a good case, Ara versus Williams. This one was the defendant was a singing coach. So he lied to the children that having sex is opening their voices. You get? So these people accepted sex hoping that they could perform or they could open their air passages to sing well. So that was a singing coach that lied to the students. So that is obtaining fraud out of obtaining consent out of fraud. You get? Then there is obtaining consent still out of threats and intimidation. Threats and intimidation, as you hear the word threat and we shall kill you what and what, which is more so common. You get? So there is a case of Uganda versus Odumuna Simon. That case provided that the accused person here was charged of rape, but for him actually, he left actually he lied the lady that she was going to kill him, what and what. Those threats and intimidation. Because actually, he even gave him certain drugs to weaken her. So the victim, in this essence, this was like even living with his father. You get? Was living with the father. The victim actually they were related. So that case of Uganda versus Dumona Simon is a good case. Then Another element is participation. Uganda versus Udimuna Simon also brings that element of participation. The prosecution must prove that it is the accused person that participated in the what? In the act. You get? As I've told you earlier that the president, before the case of, in the previous cases, there was collaboration. But in the case of Ntabala Fred versus Uganda, the precedent changed. There is no more collaboration in sexual offenses. You get? When you reach the evidence law, we don't know we don't need any more collaboration. Collaboration is that for you to prove something, it must not be a single evidence. You must bring another evidence to corroborate it to make a strong evidence. But this principle was what? Was changed, basically. But however, there are certain circumstances that prove that someone didn't consent. You get? That didn't consent. For example, existence of the struggle. You get? That shows that there was means of force. You get? Existence of the struggle. The Uganda versus Valikamanya Patrick provides for that, whereby the victims' clothes were torn, the knickers, and even the accused witnessed it. You get? So that is existence of the struggle. Then there is also a distressed condition of the victim. When the victim is distressed, Uganda versus Ospida, Emma, you get? That case provides for where the victim was distressed. Then you also have the conduct of the accused person after the alleged commission. For example, running. If he's found and runs, that conduct provides as a circumstance of lack of what? Consent. You get? If this one alarms and the other one runs, which means there was no lack of consent. Katumba James versus Uganda. That case provides for the conduct of the victim after the alleged, whereby the victim, under that case of Katumba James, the victim flew away after at the scene, after actually when the village people answered the victim's alarm, the alarm of calling for help. So meanwhile, basically that's the essence. That is basically a few about rape. And this is an offense that is so crucial. It is only on women, and it must be proved by the prosecution beyond reasonable doubt. Those are the key elements the prosecution must base on to prove that indeed there was what? There was rape, for someone to be liable and to be punished under the punishment of rape, which is under section 111. But other than, thank you for listening and thank you for watching. Stay blessed.